Out.
Yes, we can hear you, Nat.
Yes, awesome. 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 Well, welcome everyone to, gosh, I'm going to be a bit emotional. This is our last session of the year. So yeah, welcome and thank you so much that you have chosen to be with us this evening. Um, I hope you're also able to see my screen. Let me just do this. I hope it works. Voila. Can you see my second slide? The one that says who are we?
Yes, we can see.
Awesome. Awesome. So yeah, thank you and welcome to our October session of the Professional Brock series. Um, the Professional Brock series is really a story of three women. Um, those are the three women that you get to see on the screen. Um, we are from different backgrounds. One of us is a tourism expert, another one is a banker, and I am a professional accountant. And so this is a journey that we started after we individually realized that our uh, respective professional success didn't necessarily translate in wealth creation. And so each one of us had the spending habits that were not sustainable, the type of habit that would rob us from the kind of future that we were aspiring to. And so we decided to intentionally invest in our learning on how to manage our personal finances. We took a class together. We learned from experts, we read books, we listened to podcasts, we did our own research, on research. And also on this journey, we held each other accountable. And a year from our first class, we're happy that we are still on this journey together. And so we didn't also want to walk on this journey alone. We wanted to have a candid conversation with other professional women like ourselves who want to thrive financially while also creating the life that they want, but who don't necessarily know where to start from. And so in January, we kicked off, and what you're going to see on the screen is some of our personal story and our own personal aha moments. And so in January, we kicked off our first session, and we chose the word broke because we realized that being successful professionally didn't shield us from wondering where our money went towards the end of each month. And so the idea of this professional broke series is to really provide a space to empower women like ourselves to be financially literate and to take responsibility of our own financial education. So welcome. And so, like I mentioned, we started in January and we covered a number of topics. Our first session, we looked at our financial personality. We had a session on budgeting. We looked at the time value of money. We did managing debt, etc., etc. And so you can see towards the upper right side of the screen that estate planning is really our last session of the year. Not professional proxies is still around, but we're just closing off the year for this month to just give ourselves a bit of time to actually get ready for next year. And so we do have a few house rules. So this is meant to be a candid and real conversation. So we really keep it real. We forgive ourselves for our past mistakes. We try to actively participate. So at any point, if you have a question or have a comment, please use the chat box. We also avoid negative thoughts. We are intentional. We try to not compare ourselves to each other. And at the end of the day, we still want to set personal financial goals. And so with that, I would like to hand over to my colleague Francine to introduce our guest. Today's theme is quite an interesting one. It's just one of those conversations that can be very uncomfortable, but yet very important. And so I will let Francine introduce our guests. Francine, over to you.
Thank you, Natalie, and good evening to everyone. Thank you, Maggie, for accepting our invitation. And as today's session mentioned the role of estate planning on your wealth creation journey, we chose to invite Maggie as a guest speaker so that she can take us through this conversation. As an expert, you must be wondering, who is Maggie? So Maggie is a prominent lawyer in Rwanda, and she's a founder and managing partner of Shield Associate Law Firm. And she's an expert in corporate governance, commercial business transactions, and estate planning. She usually provides advisory services to corporations and businesses on tax, company, and investments in Rwanda. With her 20 years experience working for government, private sector, and international organizations in Rwanda, Maggie is also a public speaker who is passionate about the leadership, growth, and mentorship. Maggie has obtained her Bachelor of Law in Makerere University, and also a Master of Laws in Government Law and Public Policy from the University of Pacific in California. So briefly, that's who Maggie is, and let's hear what she has for us and what she has to share for us that is going to shape our future. Thank you very much. Over to you, Maggie. You're welcome to our session.
Hi, ladies. How are you? Thank you so much, Francine and Natalie, for inviting me to speak about the topic of estate planning. I hope I'm audible enough for everyone to hear me.
Yes, you were.
Yeah, that was a very kind introduction. Maybe what is missed out is that I'm also a sister to so many women. I'm also a wife to a wonderful man, and I'm also a mother to three wonderful children who are the funniest people that I know in this world. And the topic that we're discussing today is one that is very important when we are thinking about estate planning, when we're thinking about our lives, not just as women entrepreneurs, but also as members of the society. It's a theme that doesn't really sit well with many Africans, especially in our context, because every time you talk about estate planning and wills, testaments, everyone asks you and they're wondering, hey, do you want me to die? Ese urashaka komfa, you know? And there is always a stigma around talking about it. And I have noticed in so many other economies, this is one of the most lucrative practices because lawyers really invest in this and advise people, and they help. So you have a sense of certainty. So I prepared maybe like two slides. I just wanted this to be like a conversation where I'll tell you the big lines about estate planning. What is estate planning? What do you need to do estate planning? What does it involve? What type of instruments do you need? And things like that. And basically, what does the law in Rwanda talk about? And what can we think about when we're planning, like practical steps that you can actually take to take this thing seriously. So, and Natalie, can you please tell me how I can share my screen? Is it present
yes.
now?
There, you see right to there's an icon with a hand right next to it. You should be an icon with the arrow.
Yeah.
Looking up.
Yes.
So you get to choose a tab.
Okay.
It will give you options. So it's either
it says it just has one option. It says present your entire screen.
Oh, okay. Yes, you can. If that's the only thing you have on your screen, yes. Why not? Go ahead.
Okay. Let me see. Do you see anything? Oh, it's coming.
Yes, it's coming,
But
but
it's gray.
it's showing your Google Meet screen.
Oh, okay. Okay, let me stop and maybe
It should give you 3 options though. I don't know why it's
it
only giving
doesn't.
you.
It actually so it just says, let me see. It just says present your entire screen. So I actually let me
Okay.
see.
Yeah. If you do have it on email or
Maybe
a
let me
link,
send. Yeah, let me just send it to you. It's a really short presentation. Let me just send it to you
oh,
on
Alan is
email.
saying double click in the middle of your screen. Alan seems to be knowledgeable about Google Meet.
No, I mean, I think if you can present your entire screen, then you
Okay.
click in the middle, it's going to bring all the tabs, and then you
Okay.
choose the one you want to.
Okay, let me do that. Can I take off my video? Is that okay? Or do you need?
Sure,
Okay.
no problem. Let's try and see if you
Yeah.
have it on a tab or if it's a document, an offline document. I don't know.
Let me just. I think it's easier to just send it to you.
Sure. Thank you for your patience, ladies.
Yeah. Just sorry. Okay, it's sent.
Okay, let me check.
Okay.
All
So
right.
okay. Natalie, that I have is your audience just women?
Exactly.
Okay.
Yes.
Okay. 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 That's very helpful to know. But it's really not as complicated as a subject, even if sometimes people make it out to feel like it's very complicated and overwhelming. But it's really not a complication. Thank you. I can see the screen. Can you just go to the second slide? Yeah. So what is estate planning? If we just start from there, what do you think? What do you understand when someone tells you estate planning? I hope you're not thinking it's, there is a strategic plan, a business plan, a budget, and all sorts of things when you think about planning, an action plan and vision, mission. No. That's not what it is. It is basically setting up a plan, a simple plan that establish who will eventually receive your assets. And it also is a plan that makes you know how you want your affairs to be handled in the event that you're not able to handle them on your own for any reason. So it can be as simple as creating a will, or it can be as elaborate as actually creating all sorts of options that are available out there. There's a will, there's something they call a will, there's something they call a living will, there's something they call a trust. There are all sorts of documents or instruments, as we call them, that will help you plan or put your plan in motion. So there's so many misconceptions that it is just about finances, how will I want my account to be held, who will take my money, and things like that. It's so much, much more. It encompasses a lot of things. So for example, let's start by practical steps. How do you conduct estate planning? So number one, you start by creating an inventory of all your assets. And all your assets, by all your assets, I mean, it could be a house, it could be a bank account, it could be a plot of land, it could be shares or stocks or bonds, it could be investments, it could be anything, it could be clothes, it could be jewelry, it could be cars, it could be anything. Create an inventory, a document on your computer, and have everything described, like a table that says, these are my properties, you know. You have lands. If you have lands, write their UPI numbers, write their values at the time of purchasing or acquiring them. If it's clothes, describe them. If it's jewelry, describe it. If it's shares, name the company, all details, like an inventory, a comprehensive inventory. That one, you don't even need to do it for estate planning. You just need to do it because it's good manners to have all your things outlined. For example, when it comes to declaring and paying property taxes at the end of the year, you know how many people will fidget, they will do it at the last minute. Then you look for your land papers, you know, they could be in some place, they could be in the office. You don't have one place, and then you realize, oh, there's another land whose papers is where, you know. It always helps. Even without thinking about estate planning, it's a good practice to have an inventory of things that are of value to you. So that's the first step. You have a complete inventory. Now, once you have that one available, identify individuals you trust. Now, the law here makes a difference between people that you can appoint as administrators or executors of your estate and beneficiaries. For example, if you're a mom and you want your children to be beneficiaries of your estate, they can't also act as executors. So you have to find someone else to be an executor. Now, when I talk about individuals, I'm talking about people that you would really, really trust 100%. If I'm here or I'm not here, this is a person that I trust to be able to manage my affairs well. I always have this example of a parent. Imagine, God forbid, but imagine if something bad happened to you, maybe you and your significant other. The fate of your children will be left to anybody in the family who has a legal right, or who, you know, who is there, who is available. And yet, if you had put and identified a guardian and communicated someone that you choose, someone you know would treat your children the way you treat them, then you would know wherever you go, in heaven or in paradise, wherever you go, you would be knowing my children are well taken care of. But we've seen many disputes here, even in our own courts. You find that there's succession problems, someone dies, and a big brother of the person who died, according to our tradition, will come in and take over things, take care of the children. Sometimes those people are drunks. Some people, they are not as kind. Some people, they don't have the same values as you. And yet, in your circles, when you're still there, you have friends, you have confidants, you have people who have the same values as you, who see things the way you see them, who have a parenting style that you admire or that you want. And you could have left that person as a guardian for your children, and now here we are. They are just at the mercy of some family members who are not necessarily the best. Sometimes the family members will step in and they will do it because they have, but it's always good to have your affairs taken care of the way you wanted them to be taken care of, okay? Now, you identify two types of individuals. You identify an executor or administrator. In our local language, babita abegeranya imitungo. In the law, that's what the law says, abegeranya imitungo. Sometimes people refer to them as executors, sometimes they refer to them as administrators, and in as far as children are concerned, those are guardians, those are legal guardians. So if you're not there, they actually have legal rights. They will take whatever instrument that you've drafted, and they will be given the right to take care of your children. and to take care of your asset on behalf of the children. Now, the third step is now you determine and establish a will or other necessary directives. Now I'll go there. So it's when I say determine, you've decided what you want to go with. It could be a will. Now you will need to draft a will or a last testament. So a will have a list of what it will have. First of all, have a complete description of you, your age, your contact information, your address, your everything that describes you. And it will have a list of all your property that you're going to pass on to other people. It will have a list of your legal dependents. So children, husbands, those are legal dependents that the law recognizes as people who should inherit you. Sometimes you might decide otherwise, because the will is really, really binding once you're not around anymore. Now you draft the will. It could be a trust. In a bit, I'll talk about a trust. What's our difference between a will and a trust? And then a necessary medical directive. Necessary medical directive, in other words, they refer to it as a living will. It's something that actually takes effect when you're still alive. I'll talk about that in a bit. So now you draft this will. Sometimes it's always good to, once you've put your assets, an inventory of your assets, you've described your people, you've identified other individuals, it's always good to sit down with a lawyer to have like that put together in a complete document that you will that you can always keep and notarize and have it secure. So the will have all the information: who you want to take over your things, who you want to manage your things on behalf of your children if they are minor, set the date where this person's power will stop and the children will take over. You determine how that asset is going to be managed. If are they going to rent it? Do you want them never to sell it or to use it for commercial purposes? Do you want them to share? Then you also include how you want decision making to be made. If there is a conflict between your children, for example, who has the last word? When does the administrator's power come in and when do they go? So the will has all those things. Now, once you've had your will drafted, it's reviewed, you see that it captures your wishes, then you have to sign it and notarize it. It has to be signed in the presence of a notary and other witnesses. A notary is not enough. You need to have at least one other witness and the notary. You can have as many witnesses as you want, as long as the one is a minimum. Now, once you're finished, you have to go ahead and notify your executors. They don't sign your will. They're only mentioned there with their contact information, with their ID numbers or whatever description and their addresses, so that when it's necessary, they will be able to be contacted. So you notify them, you tell them what happened or what you wish. You can show them a copy of the will. You can choose to have them keep a copy of the will, and that way you know that you keep one copy with, of course, the notary. You can choose to have one filed maybe with a local administration. In some other jurisdictions, you actually have a safety security deposit box in that your executors might have access to. And then you have your documents ready. So you store them in a secure place and make sure that important people know where it is and how to access it. Now, the other thing is that you're free to update your plan as you need, as the years go by. I've actually helped many people with their wills, and after some time, even months, they'll call me back and say, "Hey, urakizi kya kibanza? You know the other plot which is in the will. By the way, I sold it, so I want to update the will. Oh, I needed money, and so the will can be updated as long as you're alive, and it is okay. You can update it, you can change it, you can remove people, you can add people. It depends on really you want." So you just have to realize it is a will is just before you go there. A will is a serious legal document. which has legal value, and it can be enforced in any court of law. You don't even need to go to court, even in local administration, once you have a will, because it's the instrument that spells out how you want your affairs handled and how you want your assets to be distributed after you die. It only comes into force after you die. And it is one of the biggest benefits, because if you don't properly prepare for what should happen in the future while you are sound and capable, you will have no say in how your estate is handled or what your loved ones receive when the time comes. When you plan today, you're ensuring that your tomorrow is exactly as you envisioned it. Okay? This plan will, it will lay out your wishes exactly as you want, not just for planning for your investments, planning for your retirement, planning for your money, how to grow, but also what will happen when you're not here anymore, so that you can trust that there won't be quarrels and issues and injustices when you could have done it otherwise. It's basically as if you continue living through your wishes through these documents. Yeah. So what law in Rwanda? How are these handled? If you go to the next slide that shows the laws, what does the law say? So the law on succession is captured in this law number 32 of 2016, which governs persons and family. In many other countries, you'll find it's called either the succession law or the succession act. But here, this is the law that governs, it governs family, divorce, custody, children, capacity to, a person's capacity to enter into contracts and everything related to family and succession and marriage and property and everything. So just for your references, this is the law, and in this law, it says that anybody who can have a will. So it's anybody who has a legal capacity to enter into a contract. So you have to be of sound mind, you have to be an adult, you have to be able to understand that what you're doing. So you can't be sick, you can't have a mental incapacitation. There is also a law, number 20 of 2013, regulating the creation of trusts and trustees. That law is sort of old, and it has a lot of things that were really missing when you compare it with other trust laws from other countries. So I think there's a cabinet resolution some months ago approving a new and updated law on trusts. One of the issues with this current law, was that it limited the trust. You could not invest in real estate under the old trust law, which is the one that's basically in force at the moment, because the new one hasn't yet come into force, even if it was approved by cabinet. So these are the two major laws that create that allow you to be able to create trusts. Now, what's the difference between a will, and a trust? Now, a trust, I don't know if maybe I'm being a little bit technical, but as I was telling you, a will is basically a legal document that regulates your affairs once you're gone. Okay, but a trust is something that comes into force when you're still alive. It is a fiduciary relationship in which a truster, or yourself, you give a trustee the right to hold title or ownership to your property or to your assets for the benefit of yourself and for others, for third parties. So, for example, you set up a trust, and once you set up a trust, you have to they call it funding. You have to fund that trust. For example, you create a trust, then you transfer your assets to that trust, and you appoint trustees. Now that trust becomes the owner of those assets that you have transferred there. And the trustees are the ones who will be managing it according to the trust deed that you establish. because they will do this work for you even while you're still alive. So when you die, you'll have had a chance to see how they manage your affairs, how they manage your finances, how they allocate things, how they take care of your finances, because they'll take care of both your finances and your liabilities, because they're actually the legal owners of the assets that you transfer there. So that is one of the biggest differences between a will and a trust. While some people will have both, and they tend to overlap, but those are the differences really. It's just that one is simple, you can sit and do it all by yourself, but a trust will actually involve registering something and that has a legal personality. And they both are basically ways that you will say who will receive your assets. They just do it in different ways, and each has its own advantages. The will has an advantage that it's simple to create, but it comes in force after you die. A trust is a little bit, it will require a little bit of paperwork, because you have to have a deed and you have to register and meet all these requirements, and you have to actually do the transfer, the actual transfer of your assets and property to that trust. So as I said, wills don't go into effect until you pass away, whereas a trust is effective immediately upon you signing it and funding it. So you have to keep in mind that once you create a trust and you have transferred assets to it, the trust is now the owner. So it's a bit, a bit of work to set it up, but it has one major benefit of a will, because you get to see how it is working when you're still alive, and you're able to influence and regulate. But the trustees are the people that actually have all sorts of obligations and liabilities for your assets. So most of the times you can choose to have either your trust as a regular trust, or you have it as an irrevocable trust. An irrevocable trust means that you cannot change it, basically, and you cannot remove, or you cannot. We usually don't. I wouldn't advise anyone to go into an irrevocable trust unless it's really something that you're sure that you will never change. As basically it's you cannot, once it is created, you cannot remove it. If you put property in the trust, you cannot take it out, for example. So this usually is preferred by people who want to avoid, going to court over issues, or having to do anything with assets. Now, there's something they call a power of attorney. So we have wills, we have trusts, and then we have a power of attorney or a necessary directive. And this usually, they call it a living will. So the living will is something that you create mostly to manage your health when you do not have, when you're not able. It's for medical purposes, okay? You're still alive. It's basically, it's like a medical care directive, but it is a document with legal value. It lets you name someone else to make decisions about your health care in case you're not able to make those decisions yourself. It gives that person, and the law calls those kinds of people, they are called agents. So in a will, the person who manages your affair is called an executor or an administrator. In a trust, the person is called a trustee. But in a medical directive or a power of attorney, a durable power of attorney, the person is called an agent, okay? So it gives the agent instructions about the kind of medical treatments you want and the kind of end of life care. I didn't want to put all those things. I'll give you a personal story. Let me first just tell you the summary of what is involved in a power of attorney, a durable power of attorney, or a living will. God forbid, we're all here today. Tomorrow you might hear that someone had a stroke and they're not able to speak, or they have forgotten how to write. and they can see what is going on. They still have their minds, they still have, but they're not able to make certain decisions. And then you watch while your life is being decided by someone else. Maybe there's a way you want things. Maybe there's something that is important to you, that you wouldn't want some people having access and control over your medical information. So this power of attorney or medical directive, it gives you give the agent to have access to and control over your medical and personal information. You give them the power to employ or hire doctors and nurses and therapists. You tell them about how you want your end of life care. For example, if you had a terminal illness and there's no, there's no cure, they're giving you days, you might have years. How would you want them to? Would you want to be plugged on those life support? What is it that you want? Who would you want to sign contracts while you're there in hospital? Maybe you're even still alive. Maybe there is hope that you're going to be cured, but there are some critical transactions that need to be taken care of when you're sick. Who executes waivers, who executes medical authorizations, who executes other urgent things? For example, if you had an urgent matter related to your child, the care that you might need, and at this point in time you're not able. Those are like temporary, because once you recuperate, you go back, you can revoke the will because you're now able to conduct business yourself, and you don't need the advocate who will be guided in making decisions about what medications to give you, what you want, what you don't want. And I experienced this firsthand when last year in 2020, at the beginning of March, I lost my mom, and it was one of those things that was very, very, very painful for us. In those last days, we had taken her to Aga Khan, and she went into a coma. She was talking 1 minute, and the next minute she wasn't talking, and they were telling us, her organs are failing, and all the major organs, the liver, the kidneys, she's on dialysis, and she's old, and they said we need a decision regarding whether we need to intubate her. Intubating means now they're going to put her on life support, and you don't know how long she will be in that vegetative state. So they were saying right now she's still hooked onto oxygen and everything, but in case she goes into cardiac arrest, do we resuscitate and do we intubate? And I remember being you're filled with so much emotion. We're praying, we're hoping that she's going to be better. I'm with a few of my siblings, and the doctor is bringing these forms and telling us, you need to decide, this is the situation. So I'm looking at this person and I'm so drained. I don't know what to do. If I sign this, it's like I'm letting my mom down. Maybe she wanted me to fight for her, to keep fighting. But then if I don't do it, maybe she didn't want to suffer, to keep suffering. She didn't want this whole pain. What do I do? And so we're going back and forth with my siblings who are back here in Kigali. And many of them are saying, Maki, maybe the reason you're there is because, God wants you to fight for Mama. How can you give up on her? And I have an older sister who was there saying, but does she really want to suffer this much? And if she's suffering like this, do we really want to, take her through the pain of intubation, and then she'll be in that vegetative state? We don't know how long. There's no hope that her organs are going to. So what do we do? Anyway, to cut the long story short, I remember thinking, why am I making these decisions? Her husband is still alive. And so we call my father, who is also old, who is devastated, who is grief-stricken. He doesn't know if his wife is coming back. This is his wife of 66 years, You think? And I was like, Papa, it's your wife, please decide, because I wanted someone else. I didn't want to be able to make a decision. And I just remember a feeling, an overwhelming sense of failure, because here I am. I've helped other people to write wills, to write medical directives, and I did not have a heart to do one for my mom. And did I ever think that they were going to live forever? Or why did I? And I was like, I have failed her, because she would have said exactly what she needed. Now, even just talking about it now, I just feel like crying, because I really felt like I had let her down. Anyway, so back and forth until my father said, can I speak to a doctor? And so he spoke to the doctor, and the doctor he said, is there hope? Is there hope that if you intubate her, maybe by some miracle, there's a medication or anything that might bring back her organs and bring her back to life? And the doctor said there was none, absolutely. So my father ended up making the decision, which took the burden away from me. And a few days later, in fact, when we made that decision, Papa made the decision, but we were the ones who were there to actually put the signature on the form. But it was like, I'm doing it for Papa, it's not me who's, and some of the sisters are crying. They're like, please don't give up on Mama. Anyway, the 2 hours after signing those forms of saying do not resuscitate, she passed. And it was one of those things. There's so much that she had wanted, there's so much that she was planning, there's so much that she was doing, but she left. And it was extremely devastating for me, because I do it for so many other people, and I didn't do it for my mom. So I said, when I have an opportunity to talk about this, I will never ever turn it down. I've had a crazy month. This has been like one of those really bad months, in terms of work, in terms of commitments that I made. I was in Guamagana today, then it was raining, then I came back racing, but I was like, I have to tell other people to not take these things for granted. So Natalie, if you can show me the last slide. I think I already talked about it, the difference between a will and a trust. And unless you have any kinds of questions, that is the end of my presentation. Yeah, ask me questions now.
Wow. I'm still reflecting on you being in a very tough spot. Thank you for sharing that story with us. Francine, over to you.
Thank you, Maggie, for the presentation. I would welcome questions, but maybe I'll start asking one. I was asking in this, where do we have a next of kin in those in the succession plans you have highlighted? Because this is because I see a lot of people struggling in the same situation. At the bank, the husband pass away, and then a wife comes and like, I'm the next of kin, and you would find like being the next of kin, that does not give you the right to be a legal successor. So it's always a confusion.
Yeah.
And I would want you to shed more light, because you see people fighting, you see wives become frustrated because maybe husbands only, or wives, they put their children. So even though they are not happy, they are still affected by the loss, but they will be wondering, why not me? Why not me? And you can read it in the face of someone. So, how are these two different, Maggie? If you can shed more light on that.
So what do you mean, the next of kin and what?
And the legal successor.
Okay. So legally speaking, a wife is a wife and a husband who have joint or community property. The law says the wife has 50% and the man has 50%. Let's say the man passes away, the law says the woman should own his 50% on behalf of the children. Part of that goes to the children. So usually if they have been legally married, the wife is legally the next of kin, if in the absence of any other thing. Now, when it comes to succession, sometimes they'll say, we need, the law actually says you need a formal family meeting where people will come and have minutes, a meeting that says we have established this one as a successor or as a next of kin. So when a wife comes and has a marriage certificate that shows there was community property, we always want to, people, even in the bank, you should ask, what matrimonial regime did you have? There are some people who have community property, there are some people who have separate property. But for married couples, it's straightforward. Now, in the case there is a will, even for married property, that will take precedence over 50% of his assets. So whatever my husband owns, I own 50% of it. So he has a right to allocate someone else to manage his 50%, but there is a 50% that belongs to me legally as a wife. Does that?
Francine, if you're speaking, you're on mute.
Sorry.
Okay.
I'm saying that if it's that automatic, why do you need a legal document to prove that way? Why you still have the marriage certificate, or you have like everything that shows that you're the wife, but you will still required to present a legal document that really confirms that you're the right person for the succession. Why is that process so complicated?
First of all, you're not entitled to everything. That's why that document is necessary. When you're a wife, you're entitled to 50% of his assets, but there is another 50% that you should have a right to by some other sort of legal instrument. Okay, so if there was 100,000 on my husband's account and I came with a marriage certificate, the bank should automatically give me 50% of that. But they will require me to bring another thing that entitles me to that whole. That is where a family meeting and a minute and an instrument, either by court or local administration, that says this person has been allocated or designated as a successor, then they can be entitled to manage and take everything. But automatically you have 50% if you've had community property. Does that make sense?
Yeah, it does. It does make sense to me.
Okay.
It does make sense to me. And yeah, I would like to hear from the audience. Does anyone have a question? Feel free to raise your hand.
I think there is a question in the chat from Aurore, and she is asking, what's your recommendation on where to keep your will, or who should keep it?
Of course, I will tell you, if you have a good lawyer, and I don't think there's a best lawyer in Kigali of wills better than myself. No, I'm kidding. But you can choose your lawyer to be. You can choose your lawyer to be the custodian of your will. You can choose to have one of the executors or administrators of your will, like someone maybe older, someone you trust in the family, to have it. But there is no guarantee. Usually you have, even in the will, you appoint an executor, at least 3, because if he dies, this one should take over as executor, because you never know who will die first. If that one dies, then this one. Usually we advise at least 3 individuals. This one is the first one, this is the second one, this is the third one. Now they should be able to keep. The other thing I have heard, I haven't yet used it, but I've heard that there are safety deposit boxes at BNR that you can actually apply for and have your important documents kept there. So those are the 3. I think of your lawyer, I think of your administrator, one person that you trust, and also at BNR for secure, or banks. Francine, in other banks don't have. Yeah, I think
the Bank of Kigali does, yes.
Yeah,
But
yeah.
again, the issue raises on who opens it?
It's
Because you
that
come,
information is in the will.
yes,
You
the
have
information.
to, yes.
Oh, but you don't let the bank read the will, because what you do, you open a safe box account, then you put in your document, you lock your box, then you take the key.
Yes.
So
Now,
it's
but
only
when your executor comes, when the administrator comes with a notarized will that authorizes
okay.
them to open, the bank will open.
Yes, it will open. Yeah.
Okay. If your question hasn't been answered, really feel free to unmute and ask. One of the questions that I had was, can you appoint someone who doesn't have any family ties as a guardian to your children?
Yes. Oh, yes, absolutely. It can be a friend, it can be someone you trust, and they legally speaking, they'll have the final say on your children.
Okay. Thank you. Sharon, I can see your hand is up.
Yeah, thanks, Natalie. Hi, Maggie, and thank you very much for a very enlightening presentation. My question is a bit strange, but I believe in organ donation. I don't think it makes sense for parts of our bodies that somebody else can make use of to be buried when they could save a life. The last time I checked, there was no legal provision for such an arrangement. And I think our medical facilities also, I think, are not advanced enough to do that now. I'm just asking if you have any updates on that. Is it part of this law, or is it something that you learned friends are considering on our behalf? Thank you.
Yeah, okay. So this is something that has is starting to be discussed, as it is a taboo. It's at the beginning of a contemplation. I'll tell you an example. There's been a very famous case, I don't know if you've heard about it, of a birth by surrogacy. A couple contracted someone to give birth for them. So their embryo, their egg and sperm were fertilized and implanted in someone else. Now, this case has just traumatized everyone in the medical field and in the legal field, because the law said, oh yeah, the woman who gave the law. We don't have any law, we don't have any precedent about such medical procedures and such. Now they're calling it ubusambanyi bukoresheje technology. It is just crazy, but it has gone up to the Supreme Court, and the parents, the biological parents, there's DNA showing this child, belongs to these ones. And the context at the beginning was the judge had said that baby should stay with a birth mother at least for the first 6 months, for the health of the child, for breastfeeding. And they were saying the biological mother could actually also breastfeed, because you don't have to have given birth to be able to breastfeed. And the judges are saying, so the absence of medical directions or medical policies related to some of these modern things that are coming up is really something that should be thought about in advance. So this case highlighted a big gap. So what happens to organs? You really want, let's say you've even put it in your will or in your medical directive and say, if I die, you should donate my eyes or my kidney. Who is going to be able to transfer those eyes to someone else? We don't even have the technology. So nobody has even, maybe if now they're saying we could do a kidney transplant, maybe because that is there, they might come up with a policy. So every law is preceded by a policy. You have to first have a policy in place. It is debated and then a law. So there is hope that there is going to be improvement and advancement in those areas. But for anyone who wants to have your organs donated, make sure you die in an advanced economy. Plan to die in a place where they can use your body parts well. Yeah.
Thank you.
Yeah. Oh, wow. Okay. I'm still reflecting on that case that went all the way up to the Supreme Court.
Yeah.
Um, I'm seeing a question from Nancy, and she says, coming back to Francine's question, you clearly explained that for married couples and the community of property assets are equally shared, so meaning 50% each. What about liabilities? Is it the same?
Oh, yeah. Oh, sorry. So, so liabilities are equally shared. So if your husband has loans and even lawsuits, you share 50%, both assets, liabilities, obligations, everything. You share 50%. Did you hear me?
Yeah, we lost you some minute, but it's okay.
Or
We can hear you.
did you hear my answer?
Yes.
Okay.
Mm.
Sometimes just as part of advice, when people are in love, they always want to go into community property, because if you say turashakiva nguramutungo, someone might think you don't love them or something. But if you just go like a wise person who wants to think, who want to help financially your entity that you're setting up, your marriage or your family, I always advise people, however much in love you are, separate. Go ivangura mutungo, that is very clear, because we've seen so many problems. You know, a man goes, drinks, obtains a loan, you accept a loan, comes, it's a liability, they will take your house. But if you didn't have that, you know, you'd still have your asset. You can say for business purposes, it makes sense to have your community, your property separated. It does not have any bearing on whether you love each other or not. You know, you could even say, let's share what we have at the beginning and separate later, or let's separate what will you know, let's put together what we'll get but what we had before, you know. But I have seen, and these are really live cases, where this couple gets married, this couple actually got married, very nice, wonderful, they're in love, and as a gift, the family of the bride gave them a house, a beautiful house, because they, you know, they had planned for their children. 1 year later, they have problems. The husband is cheating left, right. They decide to divorce, and the man took the house. You know, they had some other house, and the judge said, okay, you will divide 50-50. You take this house. So the girl said, no, because the house that the court gave her was the house they were living in, not the house the parents had given them as a gift. And so she said, no, I want to have the house my parent gave, and the husband to take the other one. And the man contested, because the house that the parent had given was really much better and had more value. They went to court over a house that the parents of the girl gave them as a gift, and the man ended up winning because he had better lawyers, he had all sorts of connections. I don't know, it was so sad and devastating, and I'm like, if they had just had their, you know, separate property, this wouldn't have happened.
Yeah, but Maggie, how do you relate that to the culture? It just reminds me of Saturday. Last Thursday, I was in a wedding, in a family wedding, and their marriage was separation. They did separate, but when this was declared in the room, everybody was like, "What? Are you for real? Why is this happening? Is it because the wife has more properties than the lady is?" So it didn't look like a normal thing, that people ended up making comments even before the during the ceremony. So how do you how do you link this with culture? That's my first question. And then how do you encourage people to keep doing this? Is there any plan for maybe campaigning for this? How is this managed at
So
the
I've actually been in such weddings where they say we separate and people in the audience goes, yo,
yes,
and you
absolutely.
hear the and you
Yes.
hear the so one thing I've always advocated for is you know how you go to register a few days before the wedding and you choose a matrimonial regime.
Mhm.
You usually you sometimes you'll say, if you have a reasonable person, you'll say, I don't want to announce this, our choice, I don't want to announce it. But then sometimes you meet people who are just rigid. They say, hey, ngomba gusoma itegeko ryose uko ryakabaye, ngomba amabwiriza avuga atya. But there's no amabwiriza which says you must read every little detail. You can say umwirondoro w'abantu, the names and everything, their dates and how they have chosen, but you don't have to say everything. Sometimes you will request, I don't want this announced. Just say bagiye gushyingiranwa imbere y'amategeko mu buryo bwemewe n'amategeko, because mu buryo bwemewe n'amategeko. But many times they will say, yamabwiriza avuga ngo ngomba kubisoma byose uko byakabaye, and there's nothing you can do unless you advocate at a high level kwa mayor, kwa minister of local government, and say for the. And one thing that I really appreciate, we have a new data protection and privacy law that has come in force. That is so exciting, because some of these laws are going to be revised, where you say, I want my privacy protected, and I don't want the public who come to my wedding to know the type of regime that I've chosen. You know, in other countries, when you've signed a prenup, not many people will know. It's just you guys, your lawyers. They don't go to announce to everyone. So for data protection, there is going to be hope. And for privacy laws, there's going to be hope to not announce these things. And you cannot go around advocating and saying, oh, please, separating mitungo. You can't. You look very, you don't look very popular, as you're saying on the cultural level. You won't be popular, but it's something to think about. Me, who is telling you that I am fully married under community property. You know, we share everything, and until now things are still fine, and wonderful. But we've actually talked about it, and we said, you know, as we grow, as we have investments, as we have children to think about, maybe we should have a separation, because it's never too late. You can apply to court, and you have separation, mutual agreement to separate. And you can say, you're a loving couple, you love each other, but you've decided to do this. And the other thing is that if you don't choose, let's say you got married in a different country and you come to Rwanda, if you did not choose a matrimonial regime, the law here assumes that it's community property. So you can't, it assumes that it's community property. Even if you say, we got married in Kenya and we did not choose a regime, they'll tell you, yeah, if you did not choose a regime, then we assume that it's community property. So,
Aline has a question. Aline, please go ahead.
Yes, thank you. I'm so happy for what Maggie just spoke last, because I'm one of that person. I got married in Uganda, and they don't choose. Yeah, so
yeah,
that this happens.
Yeah, it does.
Yes, but Maggie, again, I'm one of those people that believe somehow, I know, fully in the community. Why? Because I don't know, I would say my experience, the people that I've seen, like, I don't know how many, like 10 couples that end up staying at home, you know, because of the situation. Like, they give birth, you know, and then they stay at home, and then it's the man going to work. Somehow, like 3 of them, their career is on pause, like for 5 years. You know, there's sometimes a situation when they are mainly outside Rwanda. They live in Europe, and you know the Europe environment. You know, one of you needs to continue with work, another one stays at home. So if, for example, these people choose, to separate, then to my understanding, then I have to do a lot of calculations to say, how am I going to build my empire? Because this guy has his own stuff, I have my own. And I'm home with the kids. He cannot stay at home with the kids, for example. I have to go through pregnancy and so on and so on. Sometimes, again, in my friends, some lost their jobs, blah, blah, blah. So when you advocate for separation, how do you take this into account, or what is your experience, or how would you advise, most especially women, to go through this? Thank you.
Well, thank you. That's a really good question, because even this whole idea of regime and community property and everything came as a way for protecting women and actually helping them with, it's like empowering them economically, because most of them, as you know, traditionally they were in the kitchen and they did not have any assets. So this does not, it's not something that I would advocate blanketly with everyone. It is something that I would advise for women who are working, women who have plans, who have financial literacy, who are investing, who are working, so that someone does not take advantage of them, or you are bogged down by liabilities that have been brought about by an irresponsible husband when you're able to do yourself the other thing. So community property, community ownership of marital property is not a bad thing. And for the bulk of women, it actually provides a security and it provides empowerment. And therefore, it's not something that I would advocate for everyone. I hope that answers your question. So it's women who actually have, I have assets, I have put in as much as this man has put in. Sometimes I've actually been saying that the time that women stay at home when they're raising children or when they're pregnant, or even for women who decide I'm going to be a stay-home mother so that I can look after my children, I am a big advocate that there should never be a stigma on those women, and there should be a value, a monetary value attached to the contribution that they are making. Yeah, I was one of those who said, as soon as I get married, if I have children, I want to raise my children myself. I want to be able to have, a say. And I was lucky at the time I worked for an organization that really gave me a lot of flexibility to work from home. And I did for a long time. And the stares I got, even from my own family, they'll be like, what a waste. You should be out there doing. So there is this whole society look down upon this valuable work that women do at home. It is not valued. It is looked down upon. And nobody realized that I was actually using my brain, my education, my experience to impart into the next generation. Instead of entrusting the education, the raising of your children, if you can afford it, to people who are illiterate, because who don't even, who can't read or write, or who don't have any knowledge to impart, you're gone the whole day. And I've chosen that instead of some employer somewhere or some project that is bringing me money, why don't I take this chunk of my life, 5 years, 6 years, dedicated to these people at a time, a critical time, a formational time in their lives, so that I've made a meaningful contribution to other human beings. So we have an issue with society looking down on those roles, and that's not a good thing. And community property comes to address that. Let at least this woman have 50% of whatever she finds in this home. But for women who are willing to have their own investments, for couples who just want to advance and say, let's plan, let's have separate, just in case I have an issue here, the family shouldn't be affected, all of us. Just in case I gamble and I make a bad investment, my children should not suffer and they throw us out because I made a bad investment, So maybe one of us should have something. So it's not really a blanket statement for everyone. I hope that answers your question.
Wow. Thank you, Maggie.
Thank you so much. Maggie, then my take on this should be somehow that the separation may come in later, because most of us, or many of my contacts, they get married when they are just from school. You know, they have nothing yet. Yeah. So if they sign from the beginning separation, and maybe it happens that this man they're marrying is not good indeed, then they will still lose, yeah, than just even getting the small that they would get in the community. So thank you so much.
All right.
Mm.
Thank you, Arlene.
Yeah, and someone asked that if you're single with no children, do you need a will? Absolutely. Yes, you do need a will. Yeah, because you have property, you have people you'd want. Just imagine, you know how they say that people who die go to heaven and they are looking down upon us, you know? Imagine looking down and all your things you worked for, someone is spoiling it, someone there, they're mistreating whatever you worked for. But if you leave a will, things are happening the way you planned them, the way you wanted. Your clothes, your nice top, you know how we have those cute tops or nice shoes. Who do they go to? If you're single and you have no, give them to someone that put it in a will. Put it in a will. I really think everyone needs a will. And I'll tell you, I come from a very strong Christian background where I've actually been told that when you're creating a will, you're actually not trusting God. Because our plans and purpose, I'm a Christian, an ardent believer, Bible believing, born again Christian who believes you should have a will. Just the way when you're sick, you should go to a doctor. When you have legal trouble, you should go to a lawyer. So while my life and my fate are in God's hand, He has also given us wisdom to use our minds to actually plan. Otherwise I should have children without a break, without family planning, because my life is in God's hands. So it's really one of those things that our culture and our thinking and our perspectives really affects.
Okay. We have another question in the chat box from Elsa. She was like, what would be your advice on when, at what age to do this? How often do you advise updating a will? Assets, circumstances change? How legally binding is your will in a different country? Okay. And lastly, what happens to my asset if I die and I was living with a partner and I'm not married with? Do they automatically pass on to him? How about our kids?
Okay. So as far as age is concerned, there's really no age requirement for writing a will. There isn't an age requirement. Whenever you feel like you have things to write or to keep, to safeguard, please go ahead. There's no age requirement as long as you're an adult. And here the contractual adult is 21 to be able to enter into legally binding contracts like marriage and all sorts of things. So as long as you're above that, feel free to write an age. And how often do you advise on updating wills? It really depends. If things have changed, update. If you have sold things, update. If you have fallen out of love with whoever you had put in the will, change. If the person you had appointed as an administrator dies or is no longer accessible or is they sick, change. You have to change. So you have to keep updating as it becomes necessary. And it says how legally binding is your will in a different country. Unless, okay, so there is a universal legal principle that says when something has been conducted legally and accepted in one country, according to the laws of that country, it should be accepted in the laws of any other country, unless it is a crime in that country or something that is prohibited. So that's why a marriage conducted in Uganda will come here and be accepted as a marriage, because marriage is accepted everywhere. So it's the same. A will or a contract will be binding even when you're not in a country where you made it. Now, if you die and you are living with someone and you have children and you're not legally married, so the law of succession comes into force in that case, where they will automatically there will be a family meeting again. The children have more rights than an unmarried partner, so the family meeting will come and determine what goes where if you have not been married. So there is always, and sometimes some of these things will end up in court, because you'll need a court judgment determining who is, you have children together, but you've not been married, you have been doing all these things together. If he can prove that he contributed to creating these things that are there, then there's always a decree or a judgment or a statement that is issued that will give him rights to whatever the law has. But it's a case-by-case basis. I would need to know how many years they have been together, how many children they have, to be able to see what is the likelihood of getting something. They don't automatically go to the partner. Oh, yes. I charge a fee for writing a will, of course. It's not a big fee. Look for me. Our offices at Kigali Heights on the 3rd floor, above Java. There are some people who come and they have so many assets and they have to write 7 or 10 pages of a will. There are some who come and they have two pages. There, I will charge according to the assets and what other documents you want. You want a will? You want a medical directive? You want a trust? You want this? So there will be a fee, yeah. So come look for me. Francine has my number. We are at Shield Associates, Kigali Heights on the 3rd floor, and we usually give coffee to people who come to visit us the first time. So
Wow,
coffee from Java.
that's great. Anemone has a question. Anemone?
Yes. Thank you, Maggie, for insightful presentation. I have one question. Does a will supersede a shareholders agreement? Should a couple be business partners as well?
No. These are two separate things. A will cannot supersede a shareholders agreement, because a will cater for your own shares, not other people's shares. Okay. So if you have partners and you have a shareholders agreement, you are responsible. The agreement regulates your relationship with the other shareholders, but as far as dividends are concerned and your shares, you can say, I want to transfer my shares to a child or someone else. That is your right. And it cannot say, you cannot say because you've been a shareholder, therefore you cannot change. If you're not alive and you've left a will that says so and so takes over my shares in such and such a company, they have to oblige. The law says that person has to take over the shares. So one cannot supersede each other. They actually sort of complement. You allocate your shares, and they cannot refuse. The other shareholders cannot refuse.
Okay. What if your business partner is your spouse?
Pardon?
What if your business partner is your spouse?
So the business partner, if the business partner is your spouse,
Yes.
they have 50% rights in your shares. They have 50% rights, and the other 50%, if you're not there and you've not allocated them, they will automatically go to your children. Or if the children are young, they will go to your wife in trust. Your wife holds them in trust for the children.
Thank you.
Is it raining there? Because it's raining here and it's really loud.
It's raining here as well.
All right. I think there was a last question from Karina in the chat box.
Can you clarify the question? I don't understand. Is a traditional
family.
What does that mean?
Hello, good evening. A couple of times you mentioned that the family will have like a get together and have like a meeting, and then like who is the family? Is it inama miryango that we all know? That is I don't know, you.
Yeah. So the law says the larger family, not just the nucleus family. So, for example, if you have an issue, let's say you come together with your husband, then there will be like an uncle. Then if there is a father and a mother and an auntie, people who have some sort of relationship in the context of a cultural Rwandan family. So, for example, if you have a marital issue, who do you go to for dispute resolution? So the law will say inama y'umuryango, and they don't clearly define and say it's uncles and aunties, and inama y'umuryango could even have shefu mudugudu yaje with some uncles and aunties, and they have written it as and minuted it as inama y'umuryango. That will be accepted. But it's not just like random people you pick on the street to come and say this is inama y'umuryango. It's usually umuryango in the context of our culture. It's much bigger than a husband and a wife and children.
But in much cases, it's not defined. Hence, it can, as you said, it can be mkuru mudugudu or your uncle, your auntie. What if it's one-sided? What if it's
it has to be a representation of both sides. So if it's a family matter, there has to be both sides. On the father's side, on the mother's side, there has to be a representative. Sometimes it's an actual relative, like an auntie or an uncle. Sometimes it's an executor. For example, your dad has an executor who they have appointed, but it has to be both sides, representatives from both sides. And Chief of Mudugudu will come as a witness. And in most cases, these types of meetings will also have a notary to be able to witness and say these people were actually here and these are their signatures.
All right, thank you.
Thank you, Karine. Wow. Any other question? So should we start doing the inventory of our assets?
Yes, it's good manners. Even if you're not planning on a will right now, at least have an inventory.
Yes. And list and do a list of trustees at least. So how do you manage people? Today you can trust someone, but by the time you leave, the trust is not there. How do you manage such instances?
That's why you can update your will anytime. If your trust has reduced, you check and you've created a will, remove them from your will. You can update as long as you're alive. You can update.
Okay. Well, Natalie, I think we have to round up our session. Thank you very much.
Yeah. Yes. Thank you. I think for me, I did write like comprehensive inventory. It's one of those things that you say, one day I'll do it. One day I'll do it. And then it's time to pay the tax. Is it the taxes? I think every March, you have to take property taxes. And then and then you're like, where are those documents again? But yeah, it does make a lot of sense. In terms of the Professional Broke series, like I mentioned, we are 3 co-founders, and I'd love to actually welcome our 3rd co-founder, Carmen. If you're on the call, can you just please come off mute and come on camera? You've been very quiet, and I know you have lots of opinions and probably questions on this topic as well.
Oh, thank you so much. First of all, I would like to take this opportunity to thank our amazing speaker. Thank you so much, Maggie. Definitely, the topic we covered today was chosen on purpose to be the last one of our series. So this gives me a great opportunity to thank every single one of our call. I can see some names here. You have been very faithful. You walked the journey since January of this year. So November is here. We have not missed pretty much every month we had a session. And as I'm sure my co-founders, Natalie and Francine, highlighted, our journey does not end now. We anticipate that you will continue to walk this journey with us next year. So without any further ado, I would like just to say thank you so much to Maggie and then to everyone who has been very supportive. Your comments, your constructive our feedback made our life and then work easier. Our purpose was to share based on our own experience, because as we say, we are not professionals. That's why we bring people like Maggie, who are seasoned experts in their subject matter, to tackle all the questions where we believe we are only providing what I would call, we convene. We are the convener here. So Maggie and then everyone else here, it's been a nice journey. Hopefully everything we learn, one of our key lessons is that it's not just listening. It's information is key, but it's what you do with the information will matter. Maggie has provided her contact details. She will be happy to take you through the process. Hopefully every single step, every journey, every series, every act of our series has been very helpful toward the journey of wealth creation. And then empowerment. We created this space for women because such discussions don't happen in churches, they don't happen in our saloons, they don't happen even in our workplaces. So if this place doesn't exist, we have to create this space ourselves. So Natalie, Francine, and I, we are in our, I think this is our second year of this journey. We have learned a lot. We have, without maybe speaking on their behalf, challenge ourselves, set our goals and our ambitions. We held ourselves accountable to each other. A couple months ago, we even had our board meeting, the three of us, over breakfast. So just remember, you need to walk this journey and then have some level of accountability, and then also, if possible, a friend who's going to walk the journey with you. So I'll hand over to Natalie. Once again, Maggie, thank you. And then definitely you will hear from us soon.
Yes, you will. And I really love that, how Maggie was able to demystify this whole process. You know, step one, create an inventory. Step two, you can approach a lawyer. Think about 3 people that you trust. You can have a guardian who's not a family member. I feel like now, okay, now I can see how I can start this process, and definitely we will reach out for sure. Yeah. Thank you.
Yes, she
Thank
has
you,
already
Maggie.
shared, even her, she shared her email, she shared her phone.
Yeah, and you have to be confident that whatever information you share is highly confidential and nobody can get it. I'll give you a funny story. I was approached by a client who wanted me to help her mother write a will, and this person is the one who was paying me, you know, this daughter. And I talked with a muchechuru. She told me everything, we put everything, and then afterwards the daughter was like, "Hey, so did you?" And I said, "She's my client, you're not." So she actually thought that I would tell her, and she's like, "But I'm the one who," I said, "But it is her will and I can't." And so your information will be very, very kept confidentially.
Good to know.
Yeah.
Thank you. Thank you.
And thank you for feeling discussing. When you first said, you know, you're working, you get salary, but at the end of the day, you're like, why am I broke? Where did my money go? And then you create a solution and bring people together. That's really, really amazing. You're like disruptors. So keep it up. Keep it up.
Thank you.
Thank you. We will. That's our intention. We will be back in 2022 with a much better package. So if we have your contact information, definitely expect to hear from us.
Okay, great.
Sure.
All right. Thank you, and have a great rest of your evening, everyone.
All right. Thank you again.
Bye-bye.
Thank you
very
so
much.
much.
Thank you.
Bye.
Bye.
Thank you. Bye.